Hi, my name's Isaac Shutt. I'm an attorney licensed both in Texas and in Wyoming, and I handle mostly estate planning and probate in the state of Texas. Today I'm going to answer a question that I hear all the time, and that is, what happens to my will after I get married? And this is a great question because if you are married and then you get divorced, state law actually changes the will of the divorced people when you get divorced. And so it's a great question because, well, if I have my will and then I get married, does Texas state law automatically change my will upon marriage? And the answer is no. So if you get married after you've made your will, state law does not automatically change your will. So for example, if you have a last will and testament in Texas and you've listed your siblings as the beneficiaries in that will, and then you get married, your spouse does not automatically become a beneficiary under your last will and testament. So if you want your spouse to inherit under your will after you get married in Texas, then you need to get a new will. You need to update your will and make sure that's done validly. So you'll probably want to see an attorney and make sure that the will has the two witnesses and a notary. Just like the first time you did your will, you don't want to write on it or anything like that. You want to make sure it's done validly after you get married if you want your spouse to inherit from you after you get married. Now, it is just slightly more complicated than that in the sense that once you get married, since Texas is a community property state, your will can only give away your half of the community property. So when you pass away, everything is presumed to be 50-50 community property. So even though, let's just say you didn't put your will, or put your spouse rather, on your will as a beneficiary, and then you pass away, well, your surviving spouse then will retain her half of the community property. So it feels like she's inheriting half when you pass away, even though she wasn't even listed in your will. But if you wanted her to get everything, then you need to make sure that you go that extra step after the date of marriage and add her as a beneficiary in your last will and testament, because the state law does not automatically add your new spouse on your will. I hope you found this video helpful. If I can answer other questions, feel free to reach out. Again, my name's Isaac Shutt. I'm an estate planning attorney licensed both in Texas and in Wyoming.